So 71 reads that which of the following cases is a case of contract between Please, host, Cephas, can you mute Dorcas? I think I can mute. I'm a co-host. Okay, that's fine. Okay. So 71 says, which of the following cases is a case of contract between members? And the correct answer is Rayfield v. Hans. So this was a contract that has to do with members of a company. Remember, the members are the shareholders. So if you read this case, Rayfield v. Hans, it's related to members of a company. The contract that exists. Remember, we say there's a contract between the members and officers, the company and members, the company and officers. So move to 72. 72 says, the provisions of dash shall apply to a private company not having a registered constitution. So which provisions? So we are making reference to the second schedule. So when you read the Companies Act and when you check the second schedule has basically lay out those regulations, those rules that will apply to a company that don't have a constitution. Remember, a company is supposed to have an article of incorporation, a memorandum of association, and then what's the second one?
Article of association.
The two documents that form the constitution. Come again.
Article of association and memorandum of association.
Good, article of association. So these two things form the constitution of the company. So in the absence of these things, that is to say, if a company doesn't have a constitution, the provisions in the second schedule were applied. That's what it basically means. So Section 30 of Act 992 permits alteration of the Constitution by when you want, let me so let's just go back to the question and see what the question was asking. So the question was making reference to Section 30, right? So let's go and check Section 30 of the Companies Act.
Good evening, everyone. So sorry I came late.
Good evening. Please, you're welcome.
Thank you.
Hope you had a good Sunday.
No, the Sunday was very stressful.
Well. No, I'm not feeling well.
Oh, sorry.
Thank you.
Have you gone to the hospital or you are self-medicating?
No, I went to the hospital and the drugs I got it has waked me, so I slept. I just waked up.
Oh, sorry, you'll be fine. Now there's not the best time to get sick. You're in exams week. You'll be fine.
Thank you.
You're welcome. So please let's look at section 30. Section 30. So the heading for this section is adoption, alteration, amendments, and revocation of constitution.
Can you mute yourself?
Okay. So let's look at alteration. The shareholders or members of the company may, by special resolution, adopt a registered constitution, alter or revoke the constitution. So our concentration was on alteration. So Article 30 is correct. Okay. So let's move to 74. In the case of Do Poor Wood Treatment v. Asari, what was really said in that case? So let's just check for it online. Okay. Please, can you see my screen? Let me share again.
No, please.
No,
Can you see now?
No, please.
it's okay now.
Okay. So have you seen in the case of Do Poor Wood Treatment v. Asari, 2005 to 2007, revolves around the issue of company incorporation. In this case, the court examined the requirements and implication of incorporating a company. The court held that for a company to be validly incorporated, certain legal formalities must be followed. So you see, this is closely related to our question. And our question was basically asking, sorry, let me come back. Let me stop sharing this. So our question was basically talking about what does this case talk about? I think I'm not sharing. Let me go back and share. So do Poor Wood Treatment v. Asari. So wherein the new regulation purported to have been adopted was invalid. So that's C, which is correct. Okay. Let's move to 75. Every alteration must be effected in the interest of the company as established in the case of can you give me a minute? Just a minute.
State of financial distress, serving the country for 1 year without allowances due to government's inability.
This guy came so we chairman's picture, I'm a chairman's post. So people will be thinking maybe you have a problem with him. That's why. You see, you see, you see, you see, you see, Isaac. Am I a prophet? Hey, because immediately after the message, then you posted the message. So I knew that maybe some people would think that they are posting for particular
It's
people.
Yasnari. Can you please mute yourself for us? Thank you.
Okay, sorry, let's continue. Please, I'm pleading and I'm the only one here today. Like, trying to manage the class, sharing at the same time, telling people to mute themselves, or going to mute people is not an easy task. So please, when you join the class, just put your microphone off. I'm pleading. Okay, please, let's continue. So we are on 75. It reads, every alteration must be effective in the interest. So you say every alteration must be effected in the interest of the company. Let me share. Patience, you are now the host. Can you make me the host then? Patience Alozuke. Aluzuke. Patience, can you make me the host? Maybe she's not even here.
Derek.
Yeah, I can hear you. My network went off, so someone
Uh,
has become the host.
I'm saying that thing. Can you direct me so that I can make you a host?
No, but you are not a host.
Oh, okay.
It's only a host that can make another person a host. Okay, you hold on. Let me try and contact Cephas. Hello, Cephas, I'll be grateful if you just stay and don't leave because managing this class alone is going to be a challenge. Some people will join and their microphones will be on, and I now have to go and check on. Okay, so we continue. We're on 75. Please confirm. It says that every alteration must be effected in the interest of the company, as established in the case of Greenhall v. Adlin Cinemas Limited. So this is the case law that establishes that every alteration you make based on the company constitution, it must be made in the interest of the company. So if the alteration is not in the interest of the company, that alteration may be deemed to be illegal. 76. Which of the following are limitations on alteration of the constitution of a company? A says that alteration should not conflict with a court order in terms of remedy granted. B. Limited liability company cannot be altered to unlimited company or guarantee company to company limited by share. And D says none of the above. You know, whenever you are doing an alteration to a company's constitution, there are certain things that you cannot really alter. For example, the kind of company, if it is a limited liability, you cannot alter it to be an unlimited liability. And also, if the alteration is against the law or is against a court order, that alteration also cannot be carried out. So you cannot make any alteration that is against a court order or an alteration that would change a company from being a limited liability company to an unlimited liability company. Please, are we okay? Good. Any questions so far? Any question? Can I
Hello, sir.
proceed?
Is it a past question or
Please come again.
I'm asking whether the question you were asking is it past questions? I guess
You
join.
mean these questions we are looking at?
Yes, sir.
Yes, please. They are past questions.
Okay.
Okay. Thank you.
I hope by the end of the lecture you drop it for us to print them and look at them.
Come again.
So I hope by the end of by the close of the lecture you drop it for us to print it and look at it.
Okay, sure.
Thank you, sir.
You're welcome. 77 says the principle of lifting
Sure,
the
you
veil
do.
or piercing the corporate veil is an exception to the case of. You see, when we say lifting the veil or piercing the corporate veil, we are simply saying that an entity is an artificial legal person. However, the entity cannot take decisions by its own. Those decisions must be taken by natural person. Those natural persons act on behalf of the company. So in the event that these natural persons take some decisions which are actually not in consonance with what the company was established, the law can go after these people and try to ascertain what was actually done. And then, if they were found to be guilty, they should be able to face the penalties for it. So they cannot hide behind a veil. But there's a case law which is an exception to that, and that is Solomon v. Solomon. Okay, we continue. 78. A shareholder has the right to receive dividends when are we supposed to receive dividend? When dividend is declared. Okay. There's a difference between when dividend is announced and when dividend is declared. Who can tell us? What's the difference? The announcement of dividend is just a formal means of communication. But the declaration of the dividend, it means the company has the intention to now pay those dividends. So that's the difference between when dividends are declared and when they are announced. So we only pay dividends when they are declared, not when they are announced. So which section of the act? Yes, please.
Like in a company like this, the management and other internal auditors can say that we have made a dividend of this. Afterwards, the external auditors come to declare that this is actual dividends. Are they having any difference of that? So.
Okay, sure. Thank you. Great contribution. So 79, section dash of the act permits any person of the age of 18 and above to apply for the incorporation of a company. So which section? So this is section 12. We can cross-check. Trying to find the Companies Act. Just a minute. Please give me just a second. I'm sharing
Hello,
the
sir.
Companies Act. Yes, hello.
Yeah, good evening.
Good evening.
Yeah.
Please, can you use the slides to answer the question? With that, it will be easy for us, the student, to trace it easily. But if you are using the act itself, it will be difficult for most of us to relate to it. So if
But
it will
it's
be
not
easy for
everything.
you to answer
Yeah,
the question using the slides, it will help us. Because every
yeah,
answer to all these questions are in the slides I guessed. So if we can do that, we will appreciate it. Thank you.
yeah, I understand you perfectly. I appreciate you. But I think that will rather delay me a bit. Why am I saying that? I have to now come and search for the exact topic in the slide. But if I have the section, I just refer straight to the section in the act. Do you understand? I think that one will be more efficient than now going to the slide. And in fact, it's not everything that is in the act that is in that slide. There are certain provisions of the act that is not in the slide. I hope you agree with me on that.
Yes, I agree with you on that perfectly. It's not every provision that is in the act that is in the slides we are being given, but all the questions so far are coming from the slides. And I guess if you refer to the slide, we'll get it. But I understand your point, and that's fine. Thank you.
Okay, sure. Welcome. So this is section 14. So we are saying that the combination of subsection 1 and 2 Subsection 1 says, where the registrar is satisfied with the application for incorporation of a company complies with this act, the registrar shall, after payment of the prescribed fee, certify under the seal of the registrar that the company is incorporated, and in the case of a limited liability, that the liability of the members is limited. From the date of incorporation, the company becomes a body corporate by the name contained in the application of incorporation, and subject to Section 13 is capable of performing the function of an incorporated company. So you see, there's no need to have a certificate to commence business, as was previously the case. Once the company has complied with Section 14, subsection 1 and 2, the company is deemed to be what? Incorporated. Okay. So let's move to 81. A shareholder dash of the company. So who can be a shareholder? Can a shareholder be a debtor, a creditor? Can only be a debtor but not a creditor. D is obviously wrong. Cannot be a debtor. Who is a debtor first?
Somebody who is owing the company.
Okay.
And a creditor
So,
is somebody who the company is owing, who is financing the company's affairs. So a shareholder can be both to a company, a debtor and a creditor at the same time.
yes, that's correct. Okay. 82.
Hi. Hello.
Yeah, hello.
Let me clarify,
Good
sir.
evening.
Good evening.
Please, can you explain it? I don't understand.
Come again.
Can you explain the answer, please?
Okay. So we are saying that if you are a shareholder of a company, remember, the shareholders, they are the owners or they are the members of the company. If you are the owner of a company, it means you can be a creditor. That is to say, the company can owe you. So, for example, if I am a shareholder and the company is in difficulty, I can decide to give the company extra funds, okay, in the form of what? Credit. So in that case, I'm a creditor. But also the same way too, a shareholder can owe the company. So for example, if the shareholder takes goods on credit from the company, it means he has become what? A debtor. So he can either be a debtor or a creditor. Please, are you okay now?
Yeah, I'm okay. Thank you.
You're welcome. Let me check the chat box if there are any questions.
So if I'm getting you, you're saying that a shareholder can borrow back from the company.
When you say borrow back, like, let's put it in the better perspective. Just a minute. So if you are a shareholder of a company, you can give the company loan. The same way how you can owe the company, the company can also owe you. That's what it basically means. If the company is in difficulties and they need cash, and you, the shareholder, you have cash on you, can give the company that loan. The same way too, you can take goods from the company on credit. In that case, you become what? A debtor. I guess this explanation is fine now.
So as in this situation, is the shareholder taken from the company as I'm a bit confused, I'm sorry. Is a shareholder taking it as a shareholder or a customer? Like I'm a bit confused, as in the debtor, sorry.
So, for example, if I'm a shareholder of a company and I buy goods from my company on credit, in that case, I'm seeing both as a customer and a shareholder. Do you understand? So, in that case, I've become what? A debtor to the company. The same way how the company can also, I can also give loan to the company. That's the same way. Please, just a minute. There's some distraction. Let me just.
Hello, Lori. Hello.
Hi.
Yeah, let me try and see if I can help you on that. Sending
Okay,
the
that's fine.
shareholder being a
So,
debtor
shareholder company in both
to
ways. Information before I move to the next question.
a creditor.
Okay.
So let's assume a shareholder is not able to pay the amount of shares that is being held by him or her in a company. Then the remaining one that he is due to pay is what is making him a debtor. Does that help? If you own a share in a company, the amount of shares you are holding, the number of shares you are holding amount to a certain amount, and you will be paying that in bit, maybe first call, second call by the company. And if you are not able to pay all the amount of shares that the company has given you, meaning the remaining one that you are left to be paid become a debt on you. So in that case, you become a debtor to the company. And in case the company is going into bankruptcy or liquidation or winding up or closing down, then you will be called upon to pay that remaining debt that you are owing on your shares that you held in the company to the company. Thank
So
you.
we are saying that a shareholder can buy shares on credit.
Yes, sometimes you buy shares on credit and you don't pay all the amount of your shares to the company. Sometimes they take it in bits by calling for it. So as at when they call for it, you pay.
Okay, okay. I understand now. Thank you so much.
Welcome.
Okay, I think we can proceed now. Thank you for the explanation. Okay, 83. Once the company has complied with the requirements of incorporation in the Act, it is separate and distinct from the members, according to the case of Munko v. Kuma. Yesterday we went through this case, if you can record. So once the company is incorporated, the company has complied with all the requirements in the Companies Act. The company becomes an artificial legal person, meaning it is distinct and separate from its members. That's why it can sue, it can be sued, and all of that. And the case law that established this is Muko v. Kuma. 84. A plaintiff incorporated a company and
Hello,
sold
Mary.
his. Yes, please.
If I have a question, what is the difference between the two cases, Moko versus Kuma, and then Salomon versus Salomon and Co? What's the difference between the two cases? What principles are they referring to?
Okay, good question. So with the Solomon v. Solomon, it's simply give reference to if you read the Solomon v for the sake of better understanding, let's just go online and go through and just do a case summary. Please, can you see my screen?
It's only the question that we can see.
Hey, which person?
Yes, please.
She says only the person she can see. So, my colleague that asked the question, Senior, have you seen that with the Solomon v. Solomon, it says it established the fundamental principle of corporate personality and limited liability. Okay. The ruling affirmed that a company is a separate legal entity from its shareholders, meaning the company's debts and assets belong to the company itself. Please, are you okay with this now? Hello, can I get a feedback?
Please come again, please.
Okay. So I'm saying that when we do a summary or an overview of Solomon v. Solomon, it says that it established the fundamental principle of corporate personality and limited liability. That is to say, a company is a separate legal entity from its shareholders. That's the principle that Solomon v. Solomon established. So let's now look at the second case law.
Okay.
Can you give me the second case law?
It's Moko versus Kuma.
Thank you. So we say, let me just look for, I just want to find the legal principle. Okay, so it deals with the issue of breach of promise. So it deals with the issue of breach of promise to married. Okay. Please, are you okay?
And there is feedback, so
Oh, please kindly mute yourself. Cephas, can you mute the person? So it deals with the issue of breach of promise to married. Okay. The Moko v. Kuma. Whilst the Solomon v. Solomon deals with the issue related to what? Artificial legal person, that the company in itself is distinct and separate from the owners. So we are good to go.
Hello.
Yes, please.
the Moko versus Kuma, that's not a case. It's not about marriage. Please cross-check it for us.
Okay, don't worry. Let me just go back.
Hello, sir. Hello, sir.
Yes, please. Yes, please.
I think the Moko versus Kuma case is talking about where a company and its CEO is being sued jointly, if I'm not mistaken. But the
let
only
me just
reason
find
why
it.
I asked the question, okay.
Oh no, go ahead, please.
The only reason why I asked the question is that in case they ask a question and in the solutions, in the possible answers, they put Solomon versus Solomon and Moko versus Kuma together, which one should we go for? That is why I asked the question. I know Solomon versus Solomon stand for the separate legal entity of an incorporated company. And I know the Moko versus Kuma case is about a company and its CEO being sued jointly. That is why I asked the question. In case they put the two together, which one should we go for? I just need a clarification on that. Thank you.
Okay.
Because they are
So,
all talking
okay.
about separate legal entity. So which one is having a strong evidence in which angle so that in case we see it, we can easily identify it and pick the correct one?
Okay.
Thank you.
You're welcome. So, okay,
Mr. Derek,
yes, please.
please, to save time, if anyone has a question, he or she should jot them down. When we are done with the what you are teaching, then later on, we come out with each and everyone's question, then we solve it, then we close it. Otherwise, it will be delaying us.
Yes, I second it.
Thank you.
Okay, sure.
Yes, I move the motion.
Someone has moved and seconded the motion. Hey, you people. Okay. So I think it is clear that the Solomon v. Solomon, it established the legal personality of the company itself. But back to your question, you see, the Solomon v. Solomon is a strong case law question. Sorry, is a strong case law. So in the instance when you are doing company law, Solomon v. Solomon is a very strong. In fact, when you are doing company law, that's the very first case you may encounter. So in the instance you have the two and possible answers, which I doubt may happen, it may depend on the question also. Is that okay? My sister, I hope I've answered your question.
Yes, please, Derry, let's continue. Thank you.
Okay, yeah. Oh. Mm. 85. A company at all material times must have dash directors. How many directors must a company at all material times have? 2. A company can have one director, but that one director shouldn't last for more than, is it 3 months or 6 months? I think it's 6 months. According to the
6
Companies
months.
Act. 6 months. Okay, thank you. So at all material time, a company must have what? 2 directors at all material times.
Hello.
86. Yeah, hello.
I'm sorry, but you said a company must have one director for at least 6 months.
You cannot have more than, okay, let me put it in this perspective. You can have one director, but it shouldn't be more than 6 months.
I think it's 4 weeks.
It's 4 weeks, not 6 months, please.
Yes,
It's
yes,
4
yes.
weeks rather.
It's
Okay.
4 weeks, yes.
Yes.
Sorry, I have to revise my company law. It's been long I did one. So it's 4 weeks rather, not 6 months.
Yes.
Okay, that's fine. Correction accepted. So within the 4 weeks, you will have to find another director. You cannot have less than 2 directors after 4 weeks. Okay, let's continue. 86. It is dash for public companies to publish its annual statements of account.
Obligatory.
Obligatory. Okay, that's fine. 87. Dash is the person engaged or interested in the formation of a company.
A promoter.
A promoter. That's fine. In the breach of fiduciary duties, which of the following remedies may apply?
Rescission. Any of them.
All of them.
Okay. Damages is fine. Rescission is fine. Okay. All of them is correct. That refers to an entity with theoretically is or might be of some legal significance, but in fact lacks an identity or distinct structure of its own. What is this? This is a legal nullity.
Legal nullity, yeah.
The corporate veil may be lifted under circumstances of fraudulent trading, yes. Tax evasion, correct. Evading of contractual obligations. So any of the above is correct. Okay. 91 says a company will furnish the register within after raising its stated capital, the prescribed form showing the amount of money raised and the total stated capital. So this is
28 days.
21. Okay, 28 days. Yeah, 28 days. The veil may be lifted in the following situation except. So which situations in which the veil will not be lifted? When the name of a creditor is woefully concealed, when the company carries out business without or at least one member, when one director carries on business for more than 4 weeks. So this is what you were making reference to just some few minutes ago. So in all these instances, the veil may be lifted. So none of the above. Which of the following persons shall be liable to pay a penalty when the company carries on business with less than 2 directors for more than 4 weeks? So every director, every member, and the company in default, yes.
So you cannot see that the 4 weeks has come here.
Sorry? Yeah, the 4 weeks. An employee enter into an agreement not to compete with his former employee after ceasing employment in order to avoid this restriction. The employee set up a company and acted through that. The court held that such maneuver would not be tolerated and the veil will be lifted. This was established in which case?
It's Guildford Motor versus Horns.
Okay. You know that with this one, he was an employee of Guildford, right? And then later he resigned. After he resigned, he established his own company. And that company was like, it was in competition with his previous bosses. So they felt like the guy was just using a camouflage. So the veil was lifted. 95 reads, Dash case reinforces the fact that outside general meetings, no members or members acting alone may bind the company. So apart from, so let me just do a quick check on this one.
The answer is Besiako versus Company Marketing Board, Cocoa Marketing Board.
Okay, that's good. But let's just cross-check. Okay. Okay, that's fine. Please, Samsung SM, kindly mute yourself. Unless you are contributing and your network is and your environment is not noisy, then you can unmute yourself. Okay, 96. Which of the following statements concerning meetings is inaccurate? Meeting allow members to hire directors. Every company must hold at least 2 general meetings in each year, with intervals of not more than 15 months. Meeting allow members to exercise. So these ones, they are all correct except which one? Auditors and directors can be removed at a general meeting. That's accurate. Meetings allow members to hold directors accountable. That's correct. Meeting allow members to exercise their rights. Okay, so D is wrong. So D is the correct answer. Any meeting that may be called at any time for any purpose is referred to as may be called at any time. So this is an extraordinary meeting.
Ordinary meeting.
Okay. The quorum of a meeting depends on the type of meeting be held. Yes. Dash resolution is passed by simple majority of members who are dash either in person or by proxy. Ordinary resolutions, yes, by simple majority of people, of members who are entitled to vote actually or by their proxies. Okay, that's correct. Which of these cases below was held that the notice was invalid since the secretary lacked the capacity to convene a meeting? I think we've came across this.
Northern Engineering.
Northern Engineering, okay.
Yeah.
Should we cross-check or it's fine? Class.
It's fine.
Okay.
Fine, let's
Someone
move
says in
on.
someone says in unit 5. That's good. Good. According to section 157 of the Act 992, every company must hold at least 1 general meeting in each year with intervals not exceeding 15 months. Okay. Dash are usually held to discuss the financial reports of the company. Annual general meetings, yes. It is an offense for only one director in Ghana to convene extraordinary meeting.
Is false.
So one director can convene an extraordinary general meeting. Okay. Which of the following persons shall be subject to the same duties and liabilities as if he were a duly appointed director? A person or on whose direction or instructions the duly appointed directors are accustomed to act. Yes. Which of the following applies to the case Commodore v. Fruit Supply Ghana Limited? Let's just check.
The name of non-shareholder was printed on the company letterhead.
You've done a check on that. Okay.
Yeah.
Okay, thank you. So B is correct, confirmed.
Which unit?
Unit 5.
According to which section of the Act, every incorporated company must have at least 2 directors. So luckily we have the Act. We can just check the Act quickly. I don't have the Act here. I don't have the Act here, but I need someone to confirm this. Let me see whether I can get the Act.
At 171, at 992.
You mean section 171?
Section 171 at 992.
Okay, thank you. A director is appointed by your ordinary resolution. Okay. The directors of a company derive their power from constitution, the resolutions, either A or B. Yes, that's correct. Which of the following persons can be a director of a company? An infant with a sound mind? No. A person declared bankrupt? No. A body corporate? No. None of the above. Okay. One appointed to act as a deputy for another named director, and his subordinate in his absence is called, this is a substitute director. A director appointed to act on behalf of another director for a specified period of time, not exceeding 6 months. Not exceeding 6 months. If the director is absent from Ghana or unable, any reason to act is referred to as, this is an alternate director. So normally, when the main director is not in country, maybe for a period of 6 months, you can have an alternate director who acts on behalf of that director. It was
Hello,
held in the
Derek.
case.
Please go.
Yes, please.
Please, I want you to
Hello.
clarify and differentiate the A and D, the substitute and the alternate, because I know all of them are when the director is not around, when the director is not around.
Okay, so let's look at the actual definition. So when we talk about a substitute director, we are saying that it is one appointed to act as a deputy for another director. So that person is not a director, but he's acting on behalf of what? The main director. So you can have a substitute director at any time. But look at an alternate director. It says it is a director appointed on or behalf of another director for a specified period of time. So for an alternate director, your duration is for a specified period of time. Maybe the main director is going for a vacation for like 2 months. So we need someone to what? Be there for him as he's not around. That's an example of what? An alternate director. But a substitute director, you are appointed just as a deputy to the main director. Meaning at any time we can have what? A substitute director. But for an alternate director, it's for a specific period of time.
All right, sure. Thank you.
Okay, you're welcome. It was held in the case of Dash that the refusal of a board of directors to accept the applicant's attorney as an alternate director cannot be questioned. The attorney was not a director and there was no resolution of the board approving him. So which case states this? Let's just check.
Hi, Cedric, can I read it? Can I read the case?
Yes, please, you can read it.
Okay, so Okujeto versus Irani Brothers held that the refusal of the board of directors to accept the applicant's attorney as an alternate director cannot be questioned. The attorney was not a director, and there was no resolution of the board approving him. Neither he nor the applicant can therefore complain. Thank you.
Okay, thank you very much. So I think it is well understood. I don't need to rehash what she just said. So 113. Dash of the Companies Act defines a managing director as a director to whom it has been delegated some of the powers of the board of directors to direct and administer the business of the company. Okay, that's the fair schedule.
Derek, please can you throw more light on that side for me?
Which specific one?
The 113.
Mm-hmm. So when you check, just a minute, I really want to share the Companies Act. Let me just go online. Please, can you see my screen now?
Yes, sir.
Yes,
Okay.
please.
So if we go to the first schedule,
Just put it on there.
Hey, IB, please mute yourself.
Sunday school.
Let me make some of the co-hosts to be. Who wants to be the co-host? Where's my friend? Okay.
We're from this Sunday.
Please be checking also.
Please, what are we looking for in the arts?
Okay. We are looking for a managing director.
Okay.
So it's in the first schedule. I just hope I've not passed the first
Yes,
schedule.
page 23 of the slides is there.
Okay. Page 23 of the slides. Can you read what you have there? Oh, I'm even at the fourth schedule.
So the first schedule of Companies Act defines MD as a director to whom it has been delegated some of the powers of the board of directors to direct and administer the business of the company.
Okay. So our brother who asked the question, an MD is a director. But what distinguishes him from other directors is that he's involved in the day-to-day running of the entity. He manages the entities and all of that. So he's involved in the day-to-day running of the entity. That's the managing director. So the brother who asked the question, are you okay now?
Yes, sir. Thank you.
Okay. You're welcome. So we said Dash holds an office or place of profit under the company. So that would be an executive director, other than that of the office of an auditor, in addition to the office of a director. Okay. A director, secretary, or a liquidator are all officers of the company. All the following are duties of a company secretary except makes arrangements for board meetings, sends out notices, files returns at Registrar General, convenes general meeting.
Convenes general meeting.
Okay.
And you
Please,
go
sir.
to
Please, sir. That point I'm not all that clear.
So who
Executive
convenes
report.
the general meeting?
Director.
I see. Okay.
I think someone was saying something in addition.
Yes, I mean I don't get it. The 106. All the following are duties of a company the secretary accept. Okay, yes, I'm not clear. I'm not clear. Accept.
Yeah, clear now. Okay,
Yeah.
that's fine.
Secretary cannot convene a general meeting.
One of the following persons is not an officer of the company.
An
Yes,
auditor
obviously the
is not
auditor
an
is not. Good.
Sir.
Yes,
Hello.
please. Yes,
An
hello.
event where there is internal auditor and auditor. Which one should we go for?
An internal auditor is an officer of the company, but an auditor is not.
Okay.
An auditor here, we are making reference to external auditor.
Thank you, sir.
Independent contractor.
Thank you for adding more knowledge to us.
Accounting for.
Okay, let's continue. 118. For an appointment of an auditor for an appointment as an auditor by a private company, he must qualify under to be appointed as an
Chartered
auditor
Accountant Act 1963.
by a private company. Okay. The interests of members of a body corporate who are entitled to share in the capital or income of such body corporate is called what? This is
It's a
shares.
share.
Section 42 of Act 992 stipulates that shares have rights and liabilities attached to them, which are dependent on the terms of issues, the company's constitution, okay. So all of the above is correct. All the following are features of shares except okay, let's continue. The interest of shareholders, okay, sorry, 122. Dash is a share which does not entitle its holder to any right to participate beyond a specified amount of money in any distribution, whether by means of a dividend or on redemption in winding up. Accounting student, this one is for you. Preference share.
The preference share.
Dash is one which entitles its holder to receive his full dividend as declared for that and previous periods before dividends are payable to others.
Cumulative preference shares.
Okay. 124. A share that is capable of being acquired back by the company which issued it is called what? Redeemable
shares.
preference share. Okay. Dividend payments may be resolved by the directors, shareholders, all of the above. $125. Oh, sorry, we've done 125. 126. A written acknowledgement of indebtedness by the company setting out the terms and conditions of the loan is referred to as
debenture.
Debenture, yes.
Derek, sorry, please go back to 124. I want to confirm something to me. I beg you.
No problem.
So the redeemer ordinary share doesn't mean does not exist. or it exists but it's not part? Does it exist?
So we do have anything like redeemable ordinary share. It's not there.
Please, we don't. So we do.
We don't have. It's there to confuse you.
Okay. Okay. Thank you.
Okay. A debenture that is made irredeemable except during liquidation is known as a debenture that is made irredeemable except during liquidation is known as this is a perpetual debenture.
You are on 127 or
Oh, sorry. Okay, I've done 128. Let me now go to 127. Which of the following statements is correct? A debenture holder shall not be a member of the company. Yes,
That is correct.
it's correct. So we've done 128 already. Let's just move to 129. Where the debenture is converted into shares, it is dash issues shares for dash. It is similar issue shares for non-cash consideration. 130. A loan secured against an asset of the company is known as a loan
This one I know is
secured
A.
against any asset. So this one we don't have specific asset. So any asset. It is a naked debenture.
It's a loan unsecured. A loan that is unsecured is the naked
Against any
debenture.
asset of the company. So a
Yes.
debenture is an unsecured loan. And that unsecured loan is not against any asset. So you see, we have, if someone gives you a loan, they can tell you that this and this. Just a minute. It's fine. So they can tell you that this loan I've given you, in case you default, are we entitled to this asset, that asset, another asset? But in the case of a debenture, it's not like that. It's not against any of the assets.
Hello, Derek. No, with a debenture, it can either be a secure debenture or an unsecured debenture.
Yeah,
So
that's
the
what I'm
one
saying,
that
that
is an
this specific one.
unsecured. Okay.
Okay, let me correct myself back. So I'm saying that in this specific case, the naked debenture, it is not against any of the assets of the entity. And it is an unsecured loan. Are we okay? And it is not made against any of the assets. If it was made against some of the assets, some of them it can even be floating assets, fixed assets, and all of that. Or fixed charge, sorry. But if it is against any of the assets of the company, and that loan in itself is unsecured, it's a naked debenture. Please, is that understood or you are confused? Okay, I think we can move on. Dash is where assets are converted into cash to pay off liabilities. This is, yes, during liquidation. When the company is being liquidated, we'll sell off the assets, get cash, to pay off the liabilities. Voluntary winding up is determined by the company and its creditors by passing a special resolution. So this voluntary winding up, it is the company itself that decides to wind up. So the company will inform its creditors that, Charlie, the way things are going, we don't think that we can survive. So let's voluntarily wind up. So that one is between the company itself and its creditors. Dash occurs when there's a formal pronouncement by dissolution occurs when there's a formal pronouncement by the registrar that the company is struck off the register. Okay. Petition can be made up by a dash of the company to the register for the winding up.
All of the above.
A petition may be made to the court for the winding up of a company for the following reasons, except what the company has no members. Okay, fine. Inability to pay company debt, where it is just and equitable to do so, establish or incorporated, and they decide not to commence business within 6 months. You can't send a petition for them to be what? Wind up. Dash cannot proceed without declaration of solvency by the directors. Private liquidation. So the directors, they themselves must declare that we are insolvent. In that case, a private liquidation can go on. Okay. A private liquidation can be commenced by a passage of a special resolution, declaration of solvency to settle debt, notification to the registrar within 2 weeks of the resolution. So all of the above. Dash is an autonomous government body with perpetual succession appointed by the government, the President of Ghana, to have full control over the use of internally generated funds. So the Registrar of Companies. Okay. The Registrar of Companies shall have a governing board comprising all of the following except a representative of the Ministry of Trade and Industry. So this cannot be part of a governing board. Okay, we are at 140. Please, are we all here? Hello?
Yes, please, we are here.
Hi,
Okay.
we are here.
We got you.
Okay, thank you. So now we are on 140. Which of the following members of the board can hold office for more than 10 years? So the registrar of companies. Okay. Members of the board, except the ROC, cannot hold office for So members of a board, except the ROC, cannot hold office for 10 years and may not be appointed for more than 2 terms. Okay.
Sir, sir,
Yes, please.
think there was a 2021 or 2022, around 2019, there was a circular like that of 12 years and can be more than two terms, 12 years by the terms I didn't know of that one. So I think for CEOs of it was that particular was CEOs of rural banks. I don't know whether that one is applicable to this or is just a different thing.
Okay.
But they will extend it and say he's on contract.
Okay. Okay.
Okay.
Thank you.
The signed constitution by the members of the company, or the company secretary, may be delivered to the registrar before incorporation, after incorporation, 4 weeks before incorporation, at any time. So all of the above. Dash is the rule that requires a company to stick strictly to the category of businesses stated in their regulation. That's the ultra vires rule. Okay. We are now on 146, right? A person is disqualified from holding the position of a director of...
145.
Sorry? Oh, I jumped over 145. Sorry.
Yeah.
Which of the following is not a major change effected in the new Companies Act? Creation of the office of the registrar, no travel rules,
You do
mandatory
144.
requirements for rotation of auditors.
Hello. Frederick.
Let's finish 145.
Okay.
Yes, please. And let's finish 145. We'll go to the 144. Oh, this person. So we are on 144, right? So let me just go back. Which of the following is a requirement for qualification to appointment as a company secretary? So if you want to be appointed as a company secretary, which one of these? A person with a professional tertiary level education company, a person who has been enrolled to practice as a solicitor. All of these people can be appointed. So all of the above is correct. Do you agree?
Yes, please.
Derek, please,
Hello?
is it possible you can cross-check
You
this
agree? Okay.
from the law
That's
itself?
perfect.
Hello, Derek.
Come again.
Please, is it possible you can
Yes, I can hear
cross-check
you,
it
please.
from the law, the act itself?
Requirements for
Yes.
qualification. Okay. For qualification for appointment as a company secretary. A person with a professional or tertiary level qualification in company law practice. A person who has held office under a qualified company secretary for at least 3 years. A person who has been enrolled. Remember, a company secretary should be a lawyer. I guess you know that. Are you aware
Yes.
of that?
No.
Yes.
No.
Or you
Yes.
Or a
don't know?
chartered.
If you don't know, say you don't know.
Please, I don't know.
Or a chartered what?
A lawyer or a chartered accountant.
But Derek, I know of a law firm that they've employed a secretary who doesn't have a background.
Say a chartered. Is the chartered accountant?
So it's page 9. It's at page 9.
Okay.
Hi.
Mene anwiem kukum jamegbe. Ni ka ba on. Ni ka ba. Ni ko pa on. Okay. Mini chelo juba. Di mo ipin juba.
Ah,
Okay. Mene. Lene. Die. Mhm. Efia. Me. Efia nocturnal. Di mami ni una. Edu na ne ya pe. Efia bele mo ya pe no eche.
Ben, please mute yourself, please.
Ben, there was a book.
Please, oh, I'm back. Oh, this network has failed me again. Hello?
Hello, we can hear you. Welcome back.
Okay, thank you. Mary, can you please make me heard?
The network. Oh,
Okay.
thank God you are back.
I have, please.
Okay, thank you very much. I think we stop at 144, right?
Yes.
Yes, please.
144. Back a bit. So we're discussing this. The company secretary, and someone was saying that is on page 9. I wanted that person to just read it.
So it says qualification and regulations for the company secretary. Companies are now required to appoint a company secretary who is duly qualified professional to perform the duties of a company secretary, not just anybody above the age of majority, as in at 179. Full stop.
Wow. It says any professional. I didn't say a lawyer.
No. It
I'm
says a
surprised.
duly qualified professional.
Professional, yeah.
Yes.
So minutes
To
can even be a
perform the
chartered
duties
accountant,
of a company.
as our sister said. But this is surprising because I know
Yeah.
that normally company secretaries are lawyers. That's what I know. In practice.
Me too.
Yeah, me too.
So I'm even surprised to see this. But anyways, we are all learning. Because I know that company secretaries are normally lawyers.
Yeah, solicitors.
Well, the word is involving, so.
So,
Please, when we say
Derek,
company secretary, yes, please.
in a law firm, the secretary is also a lawyer.
No.
Because of what you are saying, that's what I'm asking. But
No,
then,
when we say secretary, who are you thinking of?
you said the secretary of a company. They are mostly
No,
lawyers.
it's not like a front desk secretary we are
A
talking about
front
here.
desk. It's not a front desk, a professional.
No. Yeah, we are
No,
talking
yeah, I
about.
know.
Okay.
But
You see,
anyway, I just wanted to ask a question. When you read the slide, in one of the questions, we said the secretary does not convene meetings. But then when you read the slides, it also says that he sets in motion the machinery to convene general meetings of members. Can you explain the difference? I don't understand this.
okay. So the secretary doesn't have
Please,
the
your line
power
is breaking. No, I can hardly hear what you are
convene
saying.
meetings. To call. But the secretary work on behalf
So Derek, your line is breaking. I don't know if it's from
of
my
the
end
board.
only,
Okay,
but I
there's a
can
to
hardly
inform
hear what you are
of the
saying.
meeting. In the meeting itself, the secretary maybe the board wants a meeting.
Hey,
Your network is very bad. We hardly hear you.
Yeah, but if anyone understands what I'm saying, if someone can explain it for me, please.
Carry out. Patience, are you okay? Was it Patience or Laurie?
I didn't
it's
hear
Laurie.
you. I don't know about the other members, but I didn't hear anything. Your line
Me
was
too.
breaking.
I didn't hear anything. The same.
Hello, Laurie.
Please, I'm here. Hello.
Okay, so concerning that issue, a secretary does not have a power to convey an annual general meeting, but a secretary can act on behalf of the directives of the director. So by sending the notice to the various members concerning the annual general meeting. So that is what it means by he or she set in motion the annual general meeting. Please, does
So
that help?
acting on behalf, that means that the director has given the secretary the power for.
Yeah, to call for. So it's the secretary that will call the various members that, we are going to have an annual general meeting, or send them a letter that, on this day we'll be having an annual general meeting. So the secretary does that on behalf of the director.
Okay. Thank you so much.
You're welcome.
Okay, I've switched my networks. Hmm. So when Cephal convenes the meeting, sorry, when Cephal sent out the meeting links and all of that, he's the one who is coordinating the meeting, but he's not the one who convenes the meeting. Do you get it? So there's a difference
Okay.
between the person who convenes the meeting and the person. Hello, let's try for one last time. If the the network goes off.
Jerry, please, we can't hear you.
Between now and 5 minutes, we'll have to find a day during the week to meet to complete. Hello, can you hear me?
The line is breaking, oh.
Hello? Have we finished? Hello?
Hello.
Please, are we close?
His line, he was saying something, but we are not getting him. So I
Hello.
don't know if he's trying to switch to get another network so that we can listen to him.
Thank you.
Please, does anyone have his number? If yes, can you call to ask him what he was trying to say so that we can go offline, please?
Hello.
Hi.
Hello?
Yeah, I was saying that if the network goes off again, we should just continue maybe tomorrow or Wednesday because I've tried everything
Okay.
possible. I've changed my networks, I've changed where I am, but still. So let's try one more time. If it goes off, then we'll continue tomorrow
It's better now.
from where we stopped. Is that okay? It's better now.
It's better now. Let's continue.
Okay. So let's try.
Oh.
Okay.
The annoying part is
Patience, please. You are the host.
Derek, I suggest the network is not helping. You can postpone it tomorrow. Maybe it will be better. It's still doing it.
Is it Patience is the host now?
Patience, can you make me the host? Sorry?
Think stage 5.
Okay, I'm the host now. So please, I'm pleading, if it goes off, then we'll just continue
Derek, please, I was
tomorrow.
suggesting you forward the past questions to us so that at least we can also go through them.
I thought you have these questions.
No, please, I don't have it.
You're on the page.
Okay. Someone says on the page.
It's on the Telegram page.
Yeah, it's on the Telegram page.
Okay, thank you very much.
You're welcome.